Hello and welcome to our today's lecture on malicious prosecution. Malicious prosecution consists in instituting unsuccessful criminal proceedings. As per institutions of civil proceedings, however malicious and unfounded, is generally not actionable. But if the proceeding result in a loss of credit to the defendants, for example, institution of bankruptcy proceedings against a trade, or winding up proceedings against a trading company maliciously and without reasonable or probable cause, an action for that lies maliciously and without reasonable and probable cause. When such a prosecution causes actual damage to the party prosecuted, it is a tort for which he can bring an action. The law authorizes persons to bring criminals to justice by instituting proceeding against them. If this authority is misused by somebody by wrongfully setting the law in motion for improper purpose, the law discourages the same. To prevent false accusations against innocent persons, an action for malicious prosecution is permitted. In an action for malicious prosecution, the plaintiff has to prove first that he was innocent and that his innocence was pronounced by the tribunal before which the accusation was made. Secondly, that there was want of reasonable and probable cause for the prosecution, or as it may be otherwise stated, that the circumstances of the case were such as to be in the eyes of the judge inconsistent with the existence of reasonable and probable cause. And lastly, that the proceedings of which he complains were initiated in a malicious spirit, that is, from an indirect and improper motive, and not in furtherance of justice. It was held in Balbandar Singh versus Badri Shah, 1926, that the plaintiff has to prove some essentials in a suit of damages for malicious prosecution. Also in KTV Krishnan versus P.T. Govindan, 1989, same was withheld. Let's know a bit about these essentials. Number 1, that he was prosecuted by the defendant. Number 2, the prosecution was instituted without any reasonable and probable cause. And number 3, the defendant acted maliciously and not with the mere intention of carrying the law into effect. Number 4, the proceedings complained of terminated in favor of the present plaintiff. Number 5, the plaintiff suffered damage as a result of the prosecution. Let's understand all of them in detail. Prosecution by the defendant. This essential ingredient requires a proof of the two elements. Number 1, that there was prosecution, and number 2, the same was instituted by the defendant. What is prosecution? It should be a criminal prosecution rather than a civil action. Prosecution means criminal proceedings against a person in a court of law. A prosecution is there when a criminal charge is made before a judicial officer or a tribunal. Proceedings before police authorities are proceedings anterior to prosecution. In Nagendranath Rai versus Basantadas Bairagya, 1929, after a theft had been committed in the defendant's house, he informed the police that he suspected the plaintiff for the same. Thereupon, the plaintiff was arrested by the police but was subsequently discharged by the magistrate, as the final police report showed that there was no evidence connecting the plaintiff with the theft. In a suit for malicious prosecution, it was held that it was not maintainable because there was no prosecution at all, as mere police proceedings are not the same thing as prosecution. When does the prosecution commence? The prosecution is not deemed to have commenced before a person is summoned to answer a complaint. Held in Ramajena versus Godadhar, 1961. In Khagendranath versus J. Bob Chandra, 1977, there were mere lodging of ijhar alleging the plaintiff wrongfully took away the blood cart belonging to the defendant and requested that something should be done. The plaintiff was neither arrested nor prosecuted. It was held that merely bringing the matter before the executive authority did not amount to prosecution, and therefore the action for malicious prosecution could not be maintained. Proceedings before a quasi-judicial authority. In D.N. Bandyopadhyay versus Union of India 1976, the Rajasthan High Court has held that departmental inquiry by disciplinary authority cannot be called a prosecution. In that case, in an inquiry regarding a train derailment, the inquiry committee found that the plaintiff, who was a weigh inspector in the defendant's railway, was guilty of negligence and was punished. The order of the disciplinary authority was set aside in a writ petition. In an action for malicious prosecution, the Rajasthan High Court held that the disciplinary authority was discharging function in a quasi-judicial manner, and it could not be called judicial authority. There was, therefore, no prosecution of the plaintiff. Prosecution should be instituted by the defendant. A prosecutor is a man who is actively instrumental in putting the law in force for prosecuting another. Although criminal proceedings are conducted in the name of the state, but for the purpose of malicious prosecution, a prosecutor is the person who instigates the proceedings. In Balbhadar versus Badri Shah 1926, the Privy Council said, "In any country where, as in India, prosecution is not private, an action for malicious prosecution in the most literal sense of the word could not be raised against any private individual, but giving information to the authorities who naturally lead to prosecution is just the same thing, and if that is done and trouble caused, an action will lie." A person cannot be deemed to be a prosecutor merely because he gives information of some offense to the police. The mere giving of information, even though it was false, to the police cannot give cause of action to the plaintiff in a suit for malicious prosecution if he, the defendant, is not proved to be the real prosecutor by establishing that he was taking active part in the prosecution, and that he was primarily and directly responsible for the prosecution. In Dattatreya Pandurang Dattar versus Hari Keshav 1949, the defendant lodged a first information report to the police regarding the theft at his shop, naming the plaintiff, which was his servant, as being suspected for the theft. After the case was registered, the police started the investigation. The plaintiff was arrested and remanded by a magistrate to police custody. On investigation, the police could not find sufficient evidence against the plaintiff, and the instance of the police, the bail bond was cancelled, and the accused, that is the plaintiff, in instant case was discharged. Thereafter, the plaintiff sued the defendant for malicious prosecution. It was held that the essential element for such an action, that the plaintiff has been prosecuted by the defendant, could not be established. The defendant had done nothing more than giving information to the police, and it is the police who acted thereafter. The defendant could not be deemed to be prosecutor of the plaintiff. In T.S. Bhatta versus A.K. Bhatta 1978, the defendant had filed a complaint against the plaintiff. Thereafter, he was not quiescent. He moved the session judge in revision. He got himself examined as a witness in session trial. He also got himself impleaded in the criminal revision before the High Court. The defendant knew the charge was false and was acting without reasonable and probable cause. It was held that the defendant was real prosecutor and was as such liable for malicious prosecution. Absence of reasonable and probable cause. The plaintiff has to prove that the defendant prosecuted him with reasonable and probable cause, as held in Ferozuddin versus Muhammad Lone 1977. Reasonable and probable cause has been defined as an honest belief in the guilt of the accused upon a full conviction, founded upon reasonable grounds of the existence of circumstances, which, assuming them to be true, would reasonably lead an ordinarily prudent man placed in the position of the accused to the conclusion that the person charged was probably of the crime imputed. There is reasonable and probable cause when the defendant has the sufficient grounds for thinking that the plaintiff was probably guilty of the crime imputed, held in Hicks versus Fokker 1878. The prosecutor need not be convinced as to the guilt or maintainability of the criminal proceedings before he files the complaint, but he may only be satisfied that there is a proper case to approach the court. Thus, neither mere suspicion is enough, nor has the prosecutor to show that he believed in the probability of the conviction held in Dawson versus Vasandao, 1863. In Satyakam versus Dalu, 1983, the defendant, Dalu, who was an illiterate villager, engaged the plaintiff Satyakam, an advocate, as his counsel in disputes of his landed property. Subsequently, in dispute of some other property of Dalu, the plaintiff took up the case of the opposite side. The defendant objected to the conduct of the plaintiff, who had defended him in earlier litigation, is now acting as an adversary. The plaintiff insisted in appearing against the defendant, and the defendant filed a complaint against the plaintiff before the disciplinary committee of the Bar Council, alleging professional misconduct on the part of the plaintiff. Before the Bar Council, the plaintiff's defense was a property in respect of which he had now taken up the case was different from the earlier one, and therefore there was no professional misconduct on his part. The Bar Council found the complaint plausible on the ground that there was some similarity in the shape and measurements of the lands in question, but only some dissimilarity of the boundary. The Bar Council, however, gave benefit of doubt to Satyakam and dismissed the defendant's complaint. Thereafter, Satyakam brought an action against Dalu, contending malicious prosecution by the latter before the Bar Council. It was observed that because of some connection and similarity between the two litigations, in the interest of the high traditions of the legal profession, the plaintiff should not have taken up the case against the old client. Under the circumstances, it was held that there was no want of bona fides and also no malice on the part of the defendant in making a complaint before the Bar Council, and therefore he was not guilty of malicious prosecution. In Yacht versus White, 1860, the defendant, the miller, noticed on the plaintiff's wharf a number of his sacks, some new which bore his marks and others old from which the mark had been cut off. Believing the sacks to be his own, the defendant charged the plaintiff for theft before a magistrate. The plaintiff was acquitted, and then he sued the defendant for malicious prosecution. It was held that since some of the sacks observed by the defendant were new, the defendant has reasonable and probable cause and was therefore not liable. Acting on the lawyer's advice is good defense, provided that the lawyer has been fully and fairly acquainted with all the relevant facts within the defendant's knowledge. In Manijay versus Sohrab, Purushottam Kotwal, 1949, the lawyer was misled and was provided with such facts which the defendant knew to be false. There was held to be want of reasonable and probable cause and also malice for which the defendant was held liable. It was no defense in this case that the defendant had acted on a lawyer's advice. The absence of reasonable and probable cause should be proved, and the same cannot be inferred from dismissal of a prosecution or acquittal of the accused, held in Bui versus Moore, 1813. In many of the cases where, however, the charge is false to the knowledge of the prosecutor, or where the falsity could be discovered by reasonable care, innocence of the accused may lead to the interference of the absence of reasonable and probable cause. Otherwise, as a general rule, innocence does not prima facie show wants of reasonable cause. For example, when the prosecutor must know whether the story which he is telling against the man whom he is prosecuting is false or true. In such case, if the accused is innocent, it follows that the prosecutor must be telling a falsehood, and there must be want of reasonable and probable cause. Or, if the circumstances proved are such that the prosecutor must know whether the accused is guilty or innocent, if he exercises reasonable care, it is only an identical proposition to infer that if the accused is innocent, there must have been a want of reasonable and probable cause. Except in cases of that kind, it is never true that mere innocence is proof of want of reasonable and probable cause. It must be innocence accompanied by such circumstances as raised the presumption that there was a want of reasonable and probable cause. Abrath versus Northeastern Railway, 1883. The burden of a proof lies on the plaintiff to show that there was an absence of reasonable and probable cause. Though as a general rule, the onus to prove absence of reasonable and probable cause rests on the plaintiff, it is subject to an exception and is qualified to this extent that in case where the accusation against the plaintiff purports to be in respect of an offence which the defendant claimed to have seen him commit, and the trial ends in acquittal on the merits, the presumption will be not only the plaintiff was innocent, but also that there was no reasonable and probable cause for the accusation. Jogendra versus Lingaraj, 1970. Thus, if the circumstances proved are such that the prosecutor must know whether the accused is guilty or innocent, there must have been a want of reasonable and probable cause, held in Saidev Prasas versus Ramnarayan, 1969. In such an exceptional situation, the burden of proof shifts on the defendant, and he can escape the liability by proving the presence of reasonable and probable cause rather than the absence of it. Malice. It is also for the plaintiff to prove that the defendant acted maliciously in prosecuting him. That is, there was malice of some indirect and illegitimate motive in the prosecutor, as held in Abrath versus Northeastern Railway Company, 1883. Per Lord Bramwell, that is, the primary purpose was something other than to bring the law into effect. KTV Krishna versus PT Govindam, 1989. It means that the defendant is actuated not with the intention of carrying the law into effect, but with an intention which was wrongful in point of fact, held in Abrath versus Northeastern Railway, 1883. Malice means the presence of some improper and wrongful motive, that is to say, intent to use the legal process in question for some other than it is legally appointed or appropriate purpose. Apart from showing that there was absence of reasonable and probable cause, it is also proved that the proceedings were initiated with a malicious spirit, that is, from an indirect and improper motive, and not in furtherance of justice. The prosecution must have been launched with an oblique motive, only with a view to harass the plaintiff, as was held in Bhogilal versus Saroj Bahen, 1979. It means a wish to injure the plaintiff rather than to vindicate the law. It is, however, not necessary to prove hatred or enmity to establishing malice, as held in Bhagwan Dutt versus Mahmud Hassan, 1983. Moreover, if the first information given by the defendant to the police is based upon the defendant's own knowledge, and information given by his brother and two eyewitnesses, the fact that there was existing enmity between the plaintiff and the defendant cannot lead to the conclusion that information given by the defendant must have been actuated by malice. With this, we come to the end of our today's lecture on malicious prosecution. Hope it was helpful, and thank you for watching.